What up? What up? I'll tell you. South Park, sometimes when I'm having a rough week, and this hasn't been a rough week, it's actually been a pretty good week up until the point where I graded our reading quizzes today, but we won't even go into that until tomorrow when I'll probably start the period where I'm ranting. But sometimes I just need a good laugh, and I watch South Park, and the episodes this week are on PC Principal, politically correct principal, who's a member of a fraternity. It is so hilarious. And Mr. Garrison is I don't know if he's running for president, but he's got like this woman that's running with him, and I think it's Melania Trump. Like they're trying to make fun of Melania Trump. I don't know, but it is hilarious. But I figured I got to do this screencast, and then I'll get back to South Park. But right to the accused. I'm going to go through these relatively quickly, but I think it's necessary to at least have the screencast so that if there's anything that is not clear in regards to the Fourth, Fifth, and Sixth Amendment, then it'll be clear after this. Again, today in the video that we watched, Gideon versus Wainwright is an important case that establishes that not only do you have a right to counsel. I changed this in the notes on my website or in my computer, but it didn't update on Google. So counsel means attorney. And so you are guaranteed a right to an attorney. And Gideon versus Wainwright establishes that if you are indigent or poor, that you still have a right to an attorney, and that will be appointed to you. So an important case, because it's not always clear, or it wasn't clear in the Constitution, whether or not if you're poor, you still had a right to an attorney. And certainly in that case, it expands the rights of individuals who are accused of a crime. The Eighth Amendment deals with two particular issues, which is cruel and unusual punishment and not being charged an excessive bail. What is bail? It means the money that you have to pay to get out of confinement or out of jail until you have proceeded to your trial. And generally speaking, if you commit a minor crime and you're going to face a judge or a jury, generally speaking, you will not have to pay bail. But in more serious crimes, you may face a bail of significant monetary value. Murder, assault and battery, etc., rape, etc. What this basically means, it's not very clear, is that if an individual is charged with a crime, a minor crime, as I mentioned today, such as stealing from a store, you're not going to be charged with a $100,000 bail. So again, it's up to the court to determine what is excessive. Now, there are some crimes that you will face, such as murder, where you may not get any bail. They may deny you bail. And that is not a violation of your rights as deemed by the courts. Trail. Did I really put that? You are guaranteed a speedy and public trial, meaning public. It doesn't necessarily mean it's on television, although some courts do televise their trials, especially the ones that receive a lot of media attention. And speedy is not very clear again. I have said multiple times that the Constitution is a very vague document in regards to its wording. So what's speedy? I don't know what's speedy. But generally speaking, as quickly as possible, you will face a trial. Many times trials last months, sometimes years, but that is at the request of the attorneys. They may want more time to interview witnesses, do a psychological background of the individual if it's a significant crime. So that would not be in violation of this particular portion of the Constitution. A grand jury determines whether or not there's enough evidence to proceed to trial. This occurs mostly in criminal cases. almost all the time in criminal cases. And so this can oftentimes be sealed, meaning it's not public. You don't know what's occurring, but a grand jury, which is called, will look at all the evidence in the investigation to determine whether there's enough to proceed to trial. These are usually high-profile cases, not cases where you're accused of a relatively minor crime. Trial by jury is something that is guaranteed by the Constitution, a jury of your peers. Typically, in most states, those juries consist of 12 people, and typically you are going to want a trial by jury and not by judge. The confrontation clause, again, I said one time, or eventually it's going to end up on the AP test. I don't think it ever has, but that's just the ability if someone accuses you of something that you have the ability to confront them during a trial and confront the charges against you. Cruel and unusual punishment is in the Eighth Amendment. Again, it's not defined as certain types of punishments. Certainly the death penalty, some would say, is cruel and unusual. The courts, however, have ruled that it is not a violation of the Eighth Amendment cruel and unusual provision. One of the preeminent cases is Furman versus Georgia. This dealt with the death penalty in Georgia, and the importance of this case is it said that when handing out the death penalty, and please be clear, the prosecutor in the whatever the crime is gets to determine whether they go for the death penalty. So if it's a really heinous crime, they're going to go for the death penalty. So the individuals who killed, 15, 16 people last week in California, if California allows a death penalty, I'm trying to think if they do, I can't remember. It will be up to the prosecutor to determine whether they're going for life in prison or the death penalty. And in that situation, because of the severity of the crime, I would imagine if they allow the death penalty, they're going to go for it. Certainly the Boston bomber situation, they went for the death penalty. When you have that type of crime, high profile, slaughter of people, innocent people, that many times prosecutors will go for the death penalty. There are several things or several types of crimes that do not fall under or have been ruled by the Supreme Court is not falling under a capital case. Capital case means a death penalty case. So individuals who are underage, if you're under the age of 18, you cannot be charged with the death penalty or a capital offense. Individuals who are mentally incompetent or mentally slow cannot be charged with a capital crime. And crimes that do not result in murder have been ruled by the Supreme Court to not be capital crimes. You cannot go for the death penalty. So there have been a lot of death penalty cases. But be clear, the court has ruled that the death penalty is not a violation of cruel and unusual punishment. Years from now, they could rule it, but as of now, in all of the decisions that they have made, they have ruled that the death penalty is not a violation of the Eighth Amendment. Finally, double jeopardy is being charged twice for the same crime. Double jeopardy. They made a movie about this. Don't watch it. It's a really ridiculous movie. But individuals cannot be charged twice for the same crime. So if the prosecution loses the first time, they can't do it over. They can't have another trial and try to do a better job. So if you've been acquitted of a crime, found not guilty, they can't try you again. Now, if new evidence should appear or should be found, they could try you again based upon that new evidence. But generally speaking, you cannot be charged twice with the same crime. So rights of the accused. Again, 4, 5, 6, especially 5, 6, deal with the rights that you have if you're charged or accused of committing a certain offense. Arrests and interrogations. So this is primarily the Fourth Amendment. Interrogations would be the Fifth Amendment. A seizure, a search and seizure, deals with a government entity. This could be the federal government, the FBI, the Department of Justice, the CIA. It could be a local government, a city, a state, police, for example. They need probable cause to secure a warrant. Probable cause means that it's more likely than not that you have committed the particular offense. They present this evidence through an investigation. This is usually done by some kind of policing agency to a judge who will then determine whether or not there's enough evidence to meet this requirement of probable cause. They would then issue a warrant if they feel that whatever the entity is, the policing entity, had met that standard. So this warrant will usually specifically reference not only a location, but the crime that has been committed. And then a search is allowed by a policing agency to secure evidence. Sometimes a search warrant is issued and you find nothing. But usually you're going to find what you're looking for. Again, it's very specific, this document, in regards to where you search. Now, it says you search a house and a vehicle. That's the only things the police can search. So again, a protection for you. Now, there are cases in which you do not need a warrant, usually for reasonable things. An automobile exception, and of course, there are cases that deal with all of these exceptions. And you don't need to get into intricate details of all of these cases. And certainly take con law if you want to get into real intricate details of these cases. And there are a variety of cases for each of these. The automobile exception says that if you pull somebody over and you establish as a police officer probable cause, you don't need to go get a warrant to search. The Terry exception deals with the case Terry v. Ohio, in which police officers saw suspicious individuals in, I believe it was Cleveland, and it appeared that they were going to rob a business. They stopped the individuals, did a pat down of their outer clothing, and noticed that they thought a gun was in, I don't know if it's pocket, it had to, I guess, be a pocket of one of the individuals. It was a gun, and they arrested him. Terry argued they had no right to stop them and pat them down. The courts ruled that if police officers feel that an individual has a weapon, they may pat them down. That does not mean a complete and thorough search. It means simply a pat down of the outer clothing. And this is only if it's thought that they have a weapon. Incidental arrest means if I arrest you, I can search the general area around you. That is perfectly legal. If you give consent before, the police don't need a warrant. Border exception, you cross the border into the United States, no warrant necessary. Plain view is a little more common. If I come to your house because I think there's a party going on and I knock on the door, you don't have to answer the door. If the police can see through a window that there appears to be illegal contraband on the table, they can then search. So if it's in plain view, you do not need a warrant. If you see something in plain view that's illegal, let me make that clear. Hot pursuit in emergencies. If I'm chasing after someone I've seen commit a crime, I don't need a warrant. If I'm going through someone's yard, etc. If I go through someone's yard and I find a patch of marijuana plants, they're in trouble. I don't need a warrant. Emergencies, if I hear someone screaming from an apartment building, I don't need a warrant to enter that building if I'm an agent of the law. Obviously, we've talked extensively in school, you have less rights in a variety of senses. Illinois versus Gates deals with anonymous tips. And what the court has ruled is if someone sends in an anonymous letter saying someone's committing a crime, that alone is not enough to secure probable cause and get a warrant. However, if you do some research, you surveil or watch the individual and things appear to be illegal, that therefore the totality of the situation can establish probable cause and a judge could issue a warrant. Some recent cases just for fun. Florida versus Jardines deals with police dogs, and in this case, a police dog The officers thought that a house was a drug house. They brought a dog without a warrant to the porch. The dog alerted that there was um, drugs or sense drugs, and they used that as a justification for getting a warrant with probable cause, and it was issued. They found drugs. The individuals in the house said you had no right to bring the dog on your porch, and they actually won. This expands the rights of individuals in this country. Police officers can't just go to suspicious houses with a drug dog if they think that drug deals are going on at the residence. Riley versus California is certainly dear to your hearts. Cell phones. If you arrest someone, even with probable cause, even with a warrant, that does not give you a right to search their cell phone. If you think that there's some illegal activity going on and you may find other individuals who are connected to the crime. You can, however, attempt to get a warrant to search the cell phone, but you definitely need a search warrant to search the contents of one's cell phone. Again, expanding your rights. Matt versus Ohio. Again, I'm going to post a video on incorporation. This is the first case that forces states to follow the Fourth Amendment. Prior to this, police officers in cities at the state level were just saying, we don't need a warrant. The Fourth Amendment does not apply to us. In Matt versus Ohio, they established that police officers at the state and local level need a warrant to search. So it incorporates the search provision of the Fourth Amendment. What's most important from this case, or what results from this case, is the exclusionary rule. If you can prove that whatever evidence was attained by a police officer or a policing agency was done in an illegal or improper manner, they can't use that evidence in a trial against you. And you'll see many situations where the police search individuals in a variety of contexts where they try to get the court to say, you know what, the search was illegal, therefore whatever evidence was gathered in the search cannot be used against you in a court of law. So you have really nothing to lose. If you have been accused of a crime due to a search, you can attempt to get the courts to say that search was faulty or illegal. There wasn't enough probable cause. And in that case, if you win, that evidence can't be used against you, and essentially you are set free. So Matt versus Ohio greatly expands the rights of individuals who are accused of crimes. And again, it's quite simple. Exclusionary rule, whatever evidence is found, if illegally, is excluded from trial. Self-incrimination. I will call this you're going to find this lame, the amendment. You do not have to testify against yourself. Why? Where do I get the S? A 5 kind of looks like an S. Shh. Don't say anything. What that means is if a police officer questions you, if they arrest you, you don't have to say anything without an attorney present, without counsel present. This results from, at least for police questioning, Miranda versus Arizona, which has appeared on the test multiple times. Certainly significant, even though Ernesto Miranda was a scumbag. So if one is questioned by the police when arrested, this is when arrested, you have these rights. They arrest you, then they ask you questions, you don't have to say a word. If you're interrogated, Escobedo or Illinois versus Escobedo, you don't have to answer any questions without an attorney once you've been arrested and taken to the police station. Habeas corpus we've talked about before, not going to spend a lot of time on that. But habeas corpus, again, is the right to know what you've been charged with. And again, if you feel that the police officers or the government is not letting you know what you're being charged with, you can request the court issue writs of habeas corpus. Earlier this week, I showed you the Supreme Court denied writs of habeas corpus to individuals. So it is, again, for the third time, the right to know what the government is charging you with. Peace.